It's multifaceted in nature, but it's the criminal and traffic code amendments under item A of our agenda this evening, and I'll turn it over to Mr. Fearborn.
Thank you, Your Honor. Over the course of the last several months, there have been a number of items that have come to the police department's attention, staff's attention, that we feel the code needs to be updated and addressed relative to new conditions that have arisen. And so Mr. Zerd, the chief, have been working really hard. Ms. Hill has been working really hard over the course of the last couple of weeks to make some recommended changes to the code, and Mr. Zerd is going to outline those for you this evening.
Thank you. Mr. Fearborn, Mayor, members of the council, I have a number of items that I've already passed out to you this evening, two items in particular. One is a quick memorandum. The way that our code has been broken down and how I'm going to present it this evening are we have 5 issues that will be addressed during the course of our conversation. That memorandum will identify sections 1, 2, 3, 4, and 5. Corresponding with that, we have a number of code provisions that we are going to be talking about doing amendments to. Those I am providing on the other sheet, and I have highlighted provisions from the revised statutes of Missouri. So in our traffic code and in our criminal code, we have referred back on many occasions to statutes in Missouri that are mere images or very near images of what we are seeking to enforce. Over the weekend, and I've been given permission to say this, I have affectionately been referring to what we are going to be proposing as my omnibus crime bill. So we're going to kind of do a bullet point coverage. I will answer any questions as we go through. These topics have all come up. Some have been presented by City Prosecuting Attorney Bill Marshall. Some have been presented by Judge Nigro. A couple of them have come directly out of the police department. And so hopefully what we've got here is kind of a culmination, very similar to what we do with the Unified Development Code from the Planning and Zoning Commission. Rather than bring these things to you in piecemeal, we're bringing them to you kind of in a bulk format. So I will dive right in. The first area that I'm going to talk about, unless people have questions before I start, the first area I'm going to talk about is domestic violence. Under the criminal code for the city of Raymore, we do have provisions that make reference to criminal or to domestic violence. And you'll see, it's the first item on the sheet that has the highlighting. The domestic violence policy is a person commits the offense of abuse if they violate any of the provisions of these sections of the revised statutes of Missouri. Bill Marshall shortly last year, close to the end of the year, advised me that in follow-up review, it appears that the sections that are related to here are very near to what the adult abuse provisions are within on the statutes in the state of Missouri. However, those particular sections, the enforcement provisions talk about child support, modification of child support, ex parte, protective orders, and things like that. Things you would see in the civil side of the world as opposed to the criminal side of the world. So very, very similar in what they are doing as far as description is concerned, but one of them results in here are your civil actions that an individual can take. What we are going to be doing is looking to take the civil references out and instead insert the criminal side of it, which would be jail time, fines, opportunities for forced training for individuals that are convicted of domestic assault and domestic violence. So the language that you see there, the section 455.010 to 455.085, on its face appears very much domestic violence oriented and adult abuse oriented. When you get into the end of it, it starts talking in terms of civil liabilities as opposed to criminal. So in order to address that, we're going to make reference to the sections that are going to be directly related to the criminal side of it. It's going to have the language in there for enforcement. We're also going to incorporate 2 definitions. One of those definitions is going to be a definition for domestic victim, a definition for family, and a definition for household members, all of which are referred back to and directly pulled from the original sections 455. So we're going to get expanded definitions. We're going to reference the criminal code as opposed to the civil code, and we're going to make sure that it is a specific reference to a domestic violence as opposed to just a generalized adult abuse. So it has additional enforcement provisions that go along with it, specifically the training for those individuals who might get convicted of domestic violence. Any questions with regard to that first section? Okay. And this was a catch by Bill Marshall. Yeah. Sorry.
Did you touch on number 3?
Yes. So allow for the criminal penalties to be applied by our municipal court, including but not limited to jail time, fines, and required classes for individuals found guilty of domestic assault. Now, the individuals that might have been victims of the abuse could also seek civil side under that section 455.010 to 455.085, but they're going to be going through the circuit court and seeking ex parte orders, orders of protection, orders to change or modify child support and child rights. Make sense?
Yep.
Okay. Sure.
So with this one and a few of the others, one of the things the council may remember is a few years ago, we brought you nearly the entire traffic section and 200 section of city code. And a lot of the changes we made, we simply took out all of the detail wording and referenced statute. So that if statute changed, we didn't have to come to you all and make the change that had been made in statute. The ones we're bringing to you tonight where you see the references to state statute, where we're expanding on that, is because either the fit, like in this one, wasn't quite perfect the way we needed it to be, or there had been wording changes to statute that don't apply to us, so while we're bringing it back in, we want to remove that statutory language from our particular code and actually go back to the detail that we had. Just kind of a summary form.
That's a great analysis, and to kind of give another example of that one, some of the language that was adopted by way of the state statute makes reference to State Department of Safety having the authority to institute regulations and rules associated with child seats, for example. We had incorporated that and wrote into our code, and rather than keep those in there, we're kind of trying to make sure and call them out because they really are never going to apply for enforcement in Raymore. So the next item that you're going to see is going to be on page 2. That's going to be section 2. I'm trying to keep these short and sweet and to have them be relatively clear and concise. If you're looking at the highlighted sheet, this is going to be chapter 210, the second item down, article 3, offenses concerning administration of justice, and section 210.100. You'll see in there a reference. We have simply indicated a person commits the offense of hindering prosecution if they violate any provisions of section 575.030. This was brought to me by Chief Wilson and a number of his officers who made a notation after the fact that when we adopted section 575.030, we actually dropped off one of the things that they use on a pretty regular basis that would normally fell within here. So somehow the state of Missouri, in its wisdom, removed this from it in later versions of their sections. Our officers believe it is important to insert it back in. So what we are seeking to do here is to reinsert language that would allow for an individual to be charged with hindering prosecution if they refuse to give a report of their name or their date of birth, or if they give a false report of their name or date of birth. So it's being reinserted back in here. We also are inserting references that it's going to be a Class A misdemeanor if someone is caught doing that. So that's the alteration that we're making there. Right now, if the adoption or what we have right now in place basically gives them 4 areas that they are able to prosecute this under for hindering prosecution, and I've listed those in the introductory paragraph at top: harboring and concealing a person, warning a person of impending discovery or apprehension, providing money, transportation, weapons, disguises, or other means to aid in avoiding the discovery, and preventing or obstructing discovery and apprehension through force, deception, or intimidation. So this one will add the 5th one to it, which is you can't give me the wrong name, you can't give me the wrong date of birth, so I can't figure out who you are.
Jonathan, if I could ask, any of those 4, is the term and or appropriately inserted anywhere? I was thinking of number 2 where it says warning a person of impending discovery and/or apprehension.
It is.
So that we could, because now both of those appear to be present in order for that specific section to be applied, and I didn't know if any of the other areas in there were appropriate for the and/or option.
So, and this is probably confusing I've made it unnecessarily confusing. I was kind of giving a Reader's Digest version of section 575.030 for those four factors.
But they're actually in the statute like that?
The statute,
or
they are
our
in as an
code?
and/or arrangement. That's correct.
Okay.
That's correct.
All right, thanks.
Good question. Good question. Okay. Any questions about section number 2? Section number 3 relates to neighborhood vehicles. This would be golf carts. I think this came to us by way of Mayor Turnbow and some follow-up discussions with Chief Wilson and Mr. Fearborn. You all have recently adopted Chapter 341 to the Code of Ordinances. That chapter addresses neighborhood vehicles or golf carts within Raymore. It requires certain equipment to be included within golf carts. It requires a registration to be included within it. It includes the authorizations that you are allowed to drive it in the city of Raymore. If you look at the highlight sheet on this page, you'll see the bottom there. We have basically 5 sections of it. The municipality's authorization. Okay, you're authorized to drive a golf cart. 2 is the neighborhood vehicle equipment and the registration. You gotta have it equipped properly. You gotta have it registered. There are certain exemptions with regard to where you are not able to drive it. And then, of course, in the next section is a detailed analysis of what all will go into the registration, and then some additional regulations and exemptions. What we did not adopt at this time, or originally under Chapter 341, was a provision that allowed for enforcement. So we are going to provide additional clarification that says, hey, look, if you violate the traffic laws in the city of Raymore, whether you're driving a big truck or a little tiny golf cart, you're going to still be cited for that. We've also expanded it based upon some of the things that we've seen in town as well, and that is individuals who are perhaps under the age of 16, not licensed to drive it, are driving around on the streets. Yeah, very
It is
hard to
actually in
enforce.
the last 3 weeks that it's had been nice weather. It is our number one complaint
So
that is being voiced to staff is that we have underage drivers in the golf carts.
you can cite the individuals if they're over the age of 16 for violating the provisions of our traffic code. When they get to under the age of 16, we feel like it's important to have some impact upon the parents at that point, or on the owners of the vehicle. So the language that we're seeking to insert is twofold. It's all going to be kind of lumped into a single provision for enforcement. The first is going to be a provision that says that any infraction of the traffic code committed by an individual on a neighborhood vehicle can be cited and prosecuted as any other offense committed in the operation of a motor vehicle. So basically, we're lumping you all in there. If you get a speeding ticket driving a souped-up golf cart, you're going to get a speeding ticket for driving a souped-up golf cart. The second one is the ability of the city clerk to revoke the city-issued registration on any neighborhood vehicle for a violation of the traffic code by individuals under the age of 16. This would be an administrative revocation, kind of like what we would see with a revocation of a business license. So if you're allowing your children under the age of 16 to drive the golf cart around and they violate or do something in violation of the traffic codes, you run the risk of having your license registration for that traffic or that golf cart revoked for a 12-month period. Yes, sir.
Why wouldn't we want to say anyone that is not licensed? Because even if they're 17 or 18, but they don't have a driver's license, I would think that's still in violation, because if they were driving a car, that would be illegal.
Actually, a change that was pointed out about 30 minutes ago to us by the city clerk, that it has to go to the driver's license. And if I could expound on this one a little bit, the difference when it's an underage driver, we had a lot of discussions on this. So you're a licensed driver in the city of Raymore, and you do a violation, but you're in a golf cart. If you have that same violation in your car, we don't take your car away. You have a spouse who may want to be driving the car. Same thing with a golf cart. If you've got you know, if you're an adult and you're licensed and there's a golf cart violation and it's you, then you still may have somebody who is licensed in the family. It's kind of an unusual situation where you're doing an equipment takeaway, but if you have somebody who is underage who you have let drive the golf cart, you've kind of abused the privilege of having the certification on the golf cart to be able to use it. So we felt an automatic 12-month revocation of that license was an appropriate violation address measure.
We did a 360 kind of conversation on this, all the way from, hey, if the children are driving it and the parents don't know that the kids are out driving it, does that qualify as neglect for not knowing that it is out? Or if they allow the children to take it out and they know they've got it out, does that qualify as endangering a child for purposes of citation? I think Chief had some really good input and comments on that one as well.
And we have charged the owners of, or the parent with child endangerment in those most serious cases where they shouldn't have been driving at all and an accident has occurred.
Yeah.
And I may be wrong because I'm not an attorney or a police officer, but I was always under the impression if I was 15 and I got pulled over driving a car without a license, that it extended the period of time before I could get a license. Is that correct?
I think that would have to be reported back to the Department of Revenue. I don't know that that's the case. I know if you're under 15, we're gonna do a juvenile referral and send it down to the juvenile office and they will handle that. Now, if you have a permit 15 and a half and above, those are treated the same as an adult.
I'm unaware of anything different.
Okay, I just didn't know, so I mean, I thought that would be a punishment if we were treating it just like a vehicle.
Yeah.
Kevin, do you have a question?
Yeah, I got a question, Chief. I know these neighborhood vehicles, they have to be inspected. And then, do the owners have to show proof of insurance like you would with a vehicle?
Yes.
And then my question would be, if you had somebody who wasn't licensed or somebody under the age of 16, technically, they wouldn't be covered for your insurance on that vehicle, just like driving your car,
Yeah,
they
they'd
wouldn't be
an
covered.
unlicensed driver. Yeah.
Right, yeah.
So they wouldn't be covered, I would imagine I can't think of any insurance that would cover an unlicensed driver. And there would be nobody under the adult age that would be trying to get their vehicle inspected. I mean, you'd have to be an adult to, or my inspectors wouldn't pass it.
I think I can, if I might, jump in real quickly on that one. Chief is absolutely right. From a motor vehicle standpoint, I don't think there's going to be any insurance out there that's going to cover it. But if it's a parent or a family member, potentially it would fall within coverage for any umbrella policy for damage they might have, or homeowner's policy for any damage they might commit. That's exactly right. But it's not going to cover them for what we would normally see for a traffic citation or for a traffic accident.
And some of them on the homeowners, it will say it has to be a non-licensed vehicle, so if it's, so I don't know what our definition, if we're actually requiring them to register it, does that make it licensed?
It does not. It is only registering it with the city of Raymore. It's not registering it as a licensed vehicle for the state of
So then
Missouri.
it would be covered under homeowners, yeah.
Yeah.
I believe right now we're registering them for 2 years.
Yes.
Okay.
Any other questions regarding, yes, sir?
Yeah, real quick. Basically, we're on 15 and a half, 16. Usually you would cite them if they have a license or a permit. Once you cite them at the citation, they got to go to court. That's automatically goes to the Missouri license. And that's when they take and extend them more years. They got a violation that they had to go to court on. That's how they know, and that's how they extend them for more years on their drive. They got to wait till 18 now to do certain things from 16 to 18.
Yeah, but that's the Department of Revenue, not
Yeah,
the city of
that's,
Raymore.
well, if we give them a citation, it'll automatically be reported to the state.
I have not had the pleasure of representing a client with that particular issue.
I mean, the comment on that would be just that if we didn't want to punish the parents by taking the registration away, the underage driver would still be punished. In a sense, the parents are punished too, because they got to wait longer to get their driver's license. So that was my only thing. If we wanted to verify that, if there was an issue, you talk like there was an issue about taking the registration away. And if that's the case, we still might be okay if all this gets reported to Department of Revenue.
Part of the concern was, and the chief kind of touched on it, why are they in the golf cart to begin with? either the parents have given him permission, and the council may be aware, we had a very serious situation last year with a golf cart rollover, and somebody was hurt and in the hospital for a very, very long time. In that case, the parent had given permission. So you either have a situation where the parent is not paying close enough attention to the vehicle where the children aren't asking for permission to take it out, but they've left it unattended, and provided can't even remember what it's called. Like if there's a pool with a fence open, an attractive hazard for these children, or you've given them permission. Either way, we feel like there needs to be some sort of an action taken against the parent, the owner of the vehicle, and the registered user of the vehicle in that case.
Mr. Baker?
So like, and I think knowledge is, like, if these were to go into effect, how would we convey that to potential golf cart recipients until it's after the fact, or would we be proactive at registration?
So my recommendation, and it's my understanding that the city clerk administers these and issues out the registrations. My recommendation is that when they sign off on that registration application, they are signing off on their understanding and knowledge of Chapter 341. If we wanted to be even more specific with it, we could include the specific enforcement provisions. But from my perspective, if you sign off and you say, yep, I'm familiarizing myself with Chapter 341, you got them.
There's actually a sheet that provides all the requirements for the actual registration to go into place, the inspection requirements. This will be added to the end of that sheet.
You said this is for a 2-year period. I guess my question would be is, from now until 2 years, would we convey it to, I mean, I don't know how many registered golf carts we have in Raymond.
177.
How many?
177.
So, I mean, I'm just saying, that, how someone's gonna plead ignorance that we didn't know that was in effect for the people that had not.
We would
pre-registered.
probably, we have the registrations. We will probably put something out to all of them because this is significant enough and it's a significant enough problem.
Yeah.
And I also think that once, upon the inspection date, we can also make sure that they're familiar with, or at least ask them if they have familiarized themselves with that statute and that part of the statute.
Yeah, I don't think it'd be a problem for the clerk to send out 177 notices of an update. Yeah. Yep.
Yeah. It'd be just a copy of the ordinance. Any other questions? Okay. Moving on to the next one. The section 355, this will change the page with regard to your highlighted portions. Section 355.010 talks about stopping, standing, or parking prohibited. Here, we had adopted 300.440 of the revised statutes of Missouri, relatively long section that covers standing, parking, or otherwise in driveways, streets, in front of fire hose or fire hydrants and things like, thank you, fire hydrants or otherwise. The only thing we had specifically called out from that was the parking in the vicinity of mailboxes. So I have that down there as well too. Unfortunately, when in looking at this and kind of reviewing it in the code, it does have some confusion to it. So we've got a first provision up at the top that says, hey, we're adopting this 300.440. It doesn't really reference and also this section as well. So kind of the goal there is to avoid having any confusion. And this section also allowed us to incorporate what I identified as the Burke rule. So there's a reference within the course of it that talks about the blocking of the sidewalk, trails, or pedestrian thoroughfares as it would cross temporary temporary driveways or permanent driveways. Essentially, you could pull in, pull out, drop people off or otherwise, but you can't really block it completely the sidewalk that would keep you from being able to walk across from sidewalk to sidewalk across a driveway, or forcing an individual pedestrian out into the street in order to get around it. View this as an ideal opportunity for, this is public health, safety, and welfare at its easiest. Kind of that approach for it. So we are incorporating and identifying out all of section 300.440, incorporating into it a reference that says you can't extended block a driveway for purpose of pedestrian access across from sidewalk to sidewalk. Questions about that? Yes, sir.
My only comment on that is, are we going to, we have problems with the trash. You know, you might not put your trash can where it's blocking the sidewalk, but when they empty it, they stick it right back, they drop it right there in the sidewalk, and people have to climb over it, around it, or whatever, because most people aren't gonna be home to put the trash can back in till later that night. So I mean, I hope, is it just something we're not gonna enforce, like empty trash cans, or?
We wouldn't do
Or
trash
do we
cans,
need to
right.
say something in there that this doesn't apply to trash cans or something?
That would not be an enforceable measure.
Okay.
Yeah. That is clearly a temporary, you know,
This one, the goal behind it, and I think Councilmember Burke kind of gave the perfect example of this, is where they're placing a large trailer that's blocking the entirety of it, or a motorhome. That's exactly correct. So it's an extended parking opportunity. Yeah.
Oftentimes, these are enforced by complaint rather than us scouring the neighborhoods to find the violation, certainly by complaint.
and they're very regular. Very regular. We see these a lot with home businesses and specifically lawn care, where the trailer is attached to the pickup and it's pulled in every evening. And so from 5 o'clock on or 7 o'clock this time of year on, you have a trailer that is constantly blocking the sidewalk, so.
And we get that complaint.
Yep. Yes, sir.
Yes, sir, I made one yesterday.
Would this be enforced by a traffic citation or a letter with 30 days to correct the situation?
Is it a law enforcement or codes?
I think it could be either.
I
Well,
would tend to agree.
It depends on where it's actually setting. If it's blocking a sidewalk, it's gonna be our typical, you get a letter, you got 30 days to correct the problem. If you don't correct it, you get a citation, you got so many days to appear in court, and when you appear in court, is the problem corrected?
I would view this as property maintenance, so Mr. Vogel will likely be issuing the citations out for that one, but nothing would stop an officer from doing the exact same thing.
And when I use the term, it would be either, it would be those vehicles that are up on the sidewalk when the sidewalk's fairly close to the roadway. So you have half the, portion of the car out in the roadway and a portion blocking the sidewalk.
Good question. Good question. Yes, sir.
I think this is a real good way to handle it because it's first and foremost an education aspect to say, hey, we would like people to safely be able to get down the sidewalk. And every once in a while, somebody had something happen and they had to run in and had to leave their vehicle there, and it won't happen again.
Yeah.
And so it's good to start out with helping people understand why we have concerns about it. Because there are some sidewalks that are just like on Lucy Webb, it's very close to the road, and it's already, you're already walking too close to the road. Thanks.
Any other questions? Moving on.
Mr. Ingrid
I'm
has a
sorry,
question.
sir.
Just one
I
real
apologize.
quick. Are fire hydrants covered in any of these sections?
So fire hydrants are going to be covered under the main section of 300.440. It's very clear with regard to that. You can't do anything in front of a fire hydrant. Yeah. Moving on to the next one is Chapter 380. This involves light regulations and other items. Now, this is the area that's probably going to see the largest amount of wordage in any potential future ordinance. And the reason for that is, it's kind of an odd one. This one comes to us from Judge Nigro and City Prosecutor Marshall, each of whom kind of made this announcement at the end of last year. It results from Senate Bill 754. 754 amended Chapter 307 of the Revised Statutes of Missouri. Chapter 307 in Missouri covers what you and I might identify as defective equipment items. Child seats, turn signals, how many lights you've got on it, do you have a foghorn on it, what are you allowed to do with tinting of windows, all of those kind of things that you might see as a defective equipment, okay? A lot of it relates to lights in particular. In Senate Bill 754, in their amendments to Chapter 307, there were references that were made to how courts can go about enforcing Chapter 307. It imposed requirements for multiple notifications, no issuances of warrants, all kinds of additional provisions in there. Judge Nigro has not been enforcing it over in Belton as far as those additional requirements, because Belton has outlined clearly the evaluation of their standalone code provisions. So it doesn't mirror 307 directly, it's their own standalone provisions, it doesn't make reference to it. Judge Nigro has made, along with Prosecutor Marshall, have made the recommendations that we kind of remove from our references the 307s, and you'll see all the highlights. We've made clear references to 307, which then allows Bill Marshall, as well as Judge Nigro, to utilize our own code for what these violations are, as opposed to being stuck to 307, which then would stick us to the notification requirements, the second notice requirements, and limitations on issuance of warrants. So,
And this is one of those statutes that is not preeminent, so we can actually have a harsher time frame that's in place. And in fact, as Mr. Zur has pointed out, 754 really extended the time frame, and on the back end of an extended time frame for being able to do anything with the violator, the last thing is all of, you did a really bad thing here, thanks for stopping by court night, and go on home. I mean, it's awful. So we really need to eliminate this, go back to the detailed language, and get our previous enforcement ability back in the hands of the judge for this.
this is the one that also incorporates the most language that's going to be removed, because it references to state agencies with authority to institute rules and regulations. So rules and regulations for child safety seats, rules and regulations for top lights and otherwise. So we are taking out the language that might be unnecessary for Raymore, because we're never going to have to deal with making rules and regulations as the state agency. That is what each of those 5 sections are going to cover. I'm happy to answer any questions you might have about that.
I would let the council know that today I had the opportunity to have an extended conversation with Judge Nigro about each of these. He likes them all. He feels like they trim things up for the court and the prosecutor, and they will come with his recommendation with the change on the driver's license has to be in place.
Just a side note for it, 99% of what we have adopted by way of reference to these statutes is doing what it's supposed to do. It is making sure that when the statutes change, our code changes along with it, so we don't have to worry about that. Do we have to update on a consistent basis? These are kind of the outliers that we've run into, that we have benefits from either going back to the way it was, or we have benefits of making changes otherwise.
Yeah. Just one quick question, just for clarification for myself. On the golf carts, you see a lot of people, they drive them on the sidewalks or they'll drive them on the grass. Will this still apply to them if they're driving on the sidewalks, or is it illegal right now for them to be driving on the sidewalks and grass? I don't know.
It is.
Okay.
Of course, golf courses and otherwise, and the trails and pathways that go along with that, but yes, it would be otherwise.
Yeah. Anybody have anything? Anything else under other?
No, sir. Just a reminder that tomorrow is Election Day. Thursday and Friday and today were not kind to us as far as tomorrow is concerned. So anybody who you can get out there and encourage them to help us out would be much appreciated.
Also, North Cache Young Life is doing a fundraiser to send kids to camp tonight at Culver's from 5 to 8. So you still have time if you want to run by,
Yeah.
get some to eat or some
There you
ice
go.
cream or make a donation.
Yeah, the Culvers is awesome, helping out the community like that. Thank you. No reason to go to executive session this time around? Okay. All right, then, wait, Tom, did you have something?
I'd like to just make a reference. Tomorrow's Election Day. I want people to get out and vote. We have a safety tax going in. 2/4%. It's a fantastic tax. It's going to help everybody in the city of Raymore. You got to understand it's threefold. One thing, it's going to be locked in verbiage that it can't go anywhere in the future, which everybody worries about. This money that comes in for the PD will be an additional money for police officers, training, cars, vests, what do we need into the future, which we do need. Compared to Belton, we're very shorthanded compared to them on officers, but we do the job. Another good thing that this will bring to us, it's locked in money for the PD forever, for long distance right now, for on and on forever. And we have one thing that the other cities don't have, people. We have 2 conglomerate stores, Walmart and Sam's. They're in Raymore. This sales tax will go for everybody who shops in Raymore. Over 50% of the people who shop at Walmart and Sam's do not live in the city of Raymore. So all that money coming in for that nice tax will come from outside our own city to supply our protection for the future of the people in the Raymore. So I really encourage everybody to vote yes on April 8th on that tax.
Thank you, sir.